There is simmering tension rippling across 3 local government areas of Delta State over the issue of delineation of electoral units. For those who are conversant with the history of the 3 major ethnic groups inhabiting the Warri axis of the state, the current back and forth between the Ishekiris and Ijos over this matter may be enough to set off the alarm bells. Well, we're now being joined by Robinson Ariyo, a lawyer, to offer his thoughts in reply to the comments on the same matter made within the week by President Ijo National Youth Congress, Jonathan Lokbobri. Good afternoon, Mr. Ariyo. Thank you so much for joining us on Newsday.
It's a pleasure, and good afternoon, listeners and viewers.
Now, during the interview, Mr. Lokbobri made it very clear that the Ijos are not seeking dominance or at war with the Ishekiris and the Urhobos. That they're just seeking a transparent counting process for better resource allocation. What are your thoughts on that?
Well, to put my response in perspective, it is important that I tell the viewers a lot they've not known about the issue. Now, this whole issue started way back in 1997 when an exercise like this was conducted and the Ishekiris went to court. The court declared it null, void, and of no effect whatsoever. Now, prior to the final judgment being delivered in 2003, the court had given an order, an interlocutory order, restraining the electoral body from utilizing the gerrymandered structure which they had put in place, which was against the 10-ward structure in Warri South. They came up with 12-ward structure. Now, despite the fact that the interlocutory injunction was in place, the body went on and continued using it even up till this day. Now, one thing that the viewers need to understand about the Supreme Court judgment is that it is one of the process leading to it is one of the biggest fraud we have ever had in human history. I will explain that to you. Now, the judgment that was delivered in 2003 was appealed against by INEC. And they did nothing about it until it was dismissed in 2018. While the process of enforcement was on, the judge and INEC conspired and went to court in another case. Not in this case. Now, it is important for us to know that the only way you can set aside a judgment is by appealing that judgment in that same case with the same parties. If you are not an initial party, you can bring an application for leave as an interested party to appeal. Now, here is the fraud. For 18 years, INEC and the judge quietly sustained the matter that led to this Supreme Court judgment and did it up to the Supreme Court, without the Ishekiris, who are the judgment creditors in the first case. Let me repeat that. You have a judgment in your favor. Now, instead of the judgment debtor to appeal it, he goes and conspires with another person without your knowledge, without joining you, and gets a judgment in that case, and now portrays that judgment as a judgment that ousts. And the important thing about this, which a lot of people don't know, is that while we were enforcing the judgment.
But I'm so sorry to interrupt you. Should the Ijos now be blamed for that, or the courts that actually had the matter, knowing that all parties involved were not present?
No, it is not. The court didn't know. They didn't disclose to the court, and that is why at the appropriate time, we will go against both the Ijo lawyer and the INEC lawyer, because it's a breach of professional conduct. You see, the point is this. If you take a look at it, to ask anybody, even ask INEC, I have a document here that I will show to you. The head of legal department in INEC in 2021 gave a legal opinion that that judgment which we had should be enforced. An 11-page document. Now, while he was doing that, he was going to court as a willing defendant. A willing defendant is somebody who agrees with the plaintiff. So they did it for 18 years. Now, when the Supreme Court gets to know that there was a judgment in which INEC was a judgment debtor, and it was not disclosed to any of the courts, from the High Court down to the Supreme Court, it was not disclosed. It's an aberration. It has never happened in living history. Now, interesting thing is that apart from the head of the legal department, the headquarters wrote to the Delta State Rec that the judgment should be obeyed. As I speak with you, the judgment has not been obeyed. Now, that is not all. You see, the interesting thing about this whole thing is that it was rigged ab initio. It was rigged before the judgment. It was rigged during the judgment. It was rigged in the course of execution of the judgment. If you are executing a judgment, that does not mean that you will not comply with the law. I'll give you an example. You can ask INEC. I wish INEC were here. A program like this would be better if you face those that you are talking about. Because as a lawyer, I deal with credible and verifiable pieces of evidence. Do you know that in the course of the execution of this judgment, the only parties that were invited to Abuja by INEC were the Jaws and the Robos. The Shekiris were never invited. And a committee was set up in Abuja there, behind the Shekiris. Interesting thing, have you asked the chairman of the committee and the job person, the superintendent, the field superintendent, and the job person? That dislocates the first pillar of justice, that you cannot be a judge in your own cause. Nemo Judesun Kasaswa. They also dislocated the second leg. When in the course, they didn't hear the Shekiris in setting up that committee. Let us leave Nigeria. Let's go to the US. Let's say there's a jury system. You have a matter, and you have to select the jurors. I excluded you, and I used you to select the juror. From that point, the process has been rigged. And that's why in law we say that no matter how beautifully conducted a proceeding is, once the principle of fair hearing, nemo judes sunt cassasua and odi alteram patem, if any of those principles is dislocated, the pillar will no longer be able to stand. And that is not all. We now wrote to INEC. We told INEC that you did not invite us for the inauguration, empowerment, and approval of the committee that you constituted. The head of the committee is an Ijaw leader of thought, Professor Rhoda Gumus. The person who reports to the head is the superintendent, Ellis, an Ijaw leader of thought. Now, I want to ask, is there anybody that will have a dispute with somebody and allow that person's father and son to be judged in that dispute? And that is why the Supreme Court has said times with that number, that the moment there's the likelihood of bias, you don't have to prove bias. But in this case, we can even prove bias. The moment there's a likelihood of bias, and you can go and cross-check it, the name of the person who chaired the process and we protested against it is an Ijaw person. The person who reports to that person who is the field officer is an Ijaw person. Now, the name INEC, the first word in INEC is independent. Neutrality. If you breach the very essence of your name, who else, what can you be taken for? You can be taken for nothing. Now, apart from the fact that there is the Constitution of the Federal Republic of Nigeria, 1999, Section 36, which says that every authority must ensure that in dealing with things like this, it is neutral, it provides, just like your station, the reason why you are giving me this opportunity now is to fulfill that principle of audio terrain pattern, the right of reply. You must hear the other side. The moment you don't, you cease to be a credible outfit. Now, INEC did not stop there. When they now decided to engage the Shekiri, they never engaged the Shekiri. They refused all the requests for appointment with the INEC chairman was reported. You can go and check. INEC chairman never had any meeting with us. Instead, he relegated us to inferior officers in Asaba. Now, when we got to Asaba, I have documents here to show to you. I can give you the soft copy. If you take a look at the advice which the head of department of INEC wrote about our judgment in 2021, just a year before the judgment, you will be amazed. He's a senior advocate of Nigeria, T.M. Inua, SAN. He said that this judgment has to be obeyed. We were sacrificed. The year the judgment was delivered was the year I was called to bar. As a matter of fact, the judgment was delivered few months before I was called to bar. I'm 23 years old at the bar today. That judgment has never been enforced. So what they now did was to fraudulently, and the lawyers who are listening to me may understand, to fraudulently begin another case behind the judgment creditor, the owner of the credit, without the judgment creditor knowing. Some of these things happen, in some part of Lagos, where a tenant is in his house, the landlord goes to court with another person who bears the tenant's name, concludes the proceedings, tenant is taking lunch, and sheriffs come. So that is a fraud of an unknown proportion that people have not seen. Take a look at the two judgments. You see that they are different parties. So how do you use one judgment to displace the other judgment? But we said, don't worry. Let us look at the execution. The execution process, again, is flawed.
Well, just for the sake of time, thank you very much for explaining this. I think anyone that's listening can make sense of exactly what it is that you are trying to put across. As the situation is right now, it sounds like a lot of legalese. What are the next steps in order to address these concerns? It also seems like you have not a lot of faith in the court system or in INEC itself.
We do have faith in court system, but INEC.
With those two parties, if you don't have faith in INEC, one party is being a bad faith player. Do you have any faith that your concerns will actually be addressed? Because this has been going on for, you said, 23 years of your legal career. So
the judiciary has been doing a perfect work. It is execution. You know, in our democracy, we have three legs: the executive arm to execute the law, the legislative arm to make the law, and the judiciary to interpret the law. In this case, the judiciary has done a perfect work interpreting the law. But the executive arm, and that is why, if you go back to section 14 of our constitution, the reason why we're a country, one of the fears that would have made Nigeria impossible was that of the minorities, that they feared that by coming into a configuration like this, they'll be marginalized in the way we have. This is a textbook case of marginalization, simply because the resources in our land is so attractive. Now, I want to ask you one question. If you were conversant with history and you call kingdoms in the Warri area, what are the kingdoms that come to your mind? Warri Kingdom. It's only recently, 2-3 years ago, that several kingdoms have been rising for the sake of what? To be able to monopolize the resources. Kingdoms are not mechanical, they are organic, like rocks. Rocks are made in thousands of years. You don't just make a kingdom 2 days ago, 3 days ago, if you want to know the truth. But you see, we have to go back to the Constitution. The government, I suggest and recommend that the federal government should set up a panel of inquiry. There should be a way to protect minorities who are amidst dragons, especially those minorities that are so gifted and endowed in resources like the Shekiris. That is the problem. And that is why you see the dog on the right is backing, the dog on the left is backing, all because if you see, the Warri Kingdom is over 500 years old. Is it just now that kingdoms? I have a judgment here, which I will show to you. This was an attempt by the Jaws to establish a kingdom in Warri. I did this matter personally. They lost. The court said, no. You don't just create. Kingdoms are not mechanical. When you talk about the Benin Kingdom,
allow me to interrupt you, for the sake of time. I'd like to follow up on what my colleague, asked you. Yes. Already we know that the Supreme Court has ruled on the, I beg your pardon, on the delineation exercise, yes. And we understand that the Supreme Court has the final say in all these legal matters. So what then is the next step? How are you going to, fight your case?
Let me explain to you. The Supreme Court does not necessarily have the final state if you can distinguish. Now, if you can tell the Supreme Court that when these parties came to you, they hid from you the existence of a judgment in which they were judgment debtors. For example, she's owing you money, okay? And she goes to an arbitrator without telling the arbitrator that she's owing you money. And behind you, presents facts to the arbitrator, and the arbitrator awards cost against you. You have a right. You have a right to go to that, to tell the arbitrator that, look, the facts were not proper. And that is one of the instances under which a court will set aside the judgment. If the judgment was obtained by fraud, and the lawyers involved, including the senior advocate, at the appropriate time, the things will be done. If you can show me a situation where another case was used to upturn a case, then I would give up my practice of law. On the same subject matter, it is a fraud that has never been done before. And that the Independent National Electoral Commission is involved in it is terrible.
Well, thank you so much for coming and having this discussion. Right of reply, Robinson, Ariyo, we wish you all the best, and you know, hopefully cooler and calmer heads shall prevail.
Thank you very much.